The Supreme Court just delivered its decision at 3:17 in the morning. A 7-2 ruling that constitutional analysts are describing as the most damaging blow to a former president in modern American history. And this was not a minor procedural issue or a narrow legal reading. It was a sweeping dismissal of executive immunity claims so complete that two of the most conservative justices on the bench broke from their usual alignment to join the majority. When Clarence Thomas and Samuel Alito find themselves outvoted by their own ideological allies, it signals that something seismic has just altered the legal landscape. Tap that subscribe button now because you will not want to miss any upcoming releases I share. So what pushed the Supreme Court to issue an emergency decision in the middle of the night? A leaked draft opinion obtained by multiple major outlets shows the justices determined that the constitutional arguments presented were, in the words of Chief Justice Roberts, fundamentally incompatible with the rule of law itself. This is not simply another courtroom loss, or a temporary legal hurdle. Members of Trump's own legal team are privately conceding that the ruling effectively removes every remaining barrier between their client and federal prosecution. And believe me, when Supreme Court justices issue emergency rulings at 3 a.m., it means something extraordinary has just occurred. It is genuinely difficult to grasp that we are watching the nation's highest court issue such a comprehensive rejection of presidential immunity, while most Americans were asleep. But that is exactly what makes this decision so remarkable. Here is the complete picture of how events unfolded. Tensions between the executive branch and the judiciary had been building for months, driven by repeated efforts to delay federal proceedings, challenges to special counsel authority, and escalating disputes over document production. But everything reached a tipping point on January 15 when the D.C. Circuit Court certified an emergency appeal directly to the Supreme Court after Trump's attorneys filed what prosecutors described as the most expansive immunity claim in presidential history. The filing, submitted just 72 hours before the ruling, argued that a former president retains absolute immunity from criminal prosecution for any actions taken while in office, regardless of whether those actions were official or personal, lawful or unlawful. Legal experts immediately recognized this as a last-ditch effort to establish a precedent that would permanently place presidents above the law. This was not about safeguarding executive privilege or protecting national security interests. It was about constructing a constitutional shield that no future court could ever breach. The document, spanning 127 pages, cited historical precedents dating back to the founding era. However, constitutional scholars reviewing the submission observed that the arguments selectively quoted sources out of context and distorted the founders' clear intent that no individual should stand above the law. The sheer boldness of the claims stunned even seasoned Supreme Court observers who believed they had seen it all. Hit that like button if this is making sense so far. Here is where the situation becomes truly serious. When the justices reviewed the emergency petition during their private conference, sources familiar with the discussion say the reaction was immediate and visceral. Even justices who had previously shown openness to broad executive authority acknowledged that accepting these arguments would fundamentally reshape the American presidency into something the founders never envisioned. And let's be candid for a moment. Emergency overnight rulings from the Supreme Court are exceedingly rare. They do not occur over routine disputes or procedural technicalities. They happen when the justices believe the constitutional order itself is threatened and delay would cause irreversible harm. Here is what multiple sources indicate happened next. On January 16, Chief Justice John Roberts convened an emergency conference call at 9:47 p.m. after reviewing the government's response brief. The call lasted nearly 4 hours. Sources told CNN that Justice Amy Coney Barrett reportedly said the immunity arguments were disconnected from any recognizable constitutional principle. At the same time, Justice Neil Gorsuch, who is often aligned with conservative viewpoints, reportedly described the filings' logic as an invitation to tyranny that would horrify the founders. Justice Brett Kavanaugh, previously viewed as potentially receptive to executive power arguments, allegedly stated during the call that there are boundaries that cannot be crossed without destroying the republic itself. The justices understood they were making history. They understood the political backlash that would follow. And yet 7 of them concluded that the Constitution required this outcome. By 2:30 a.m., the justices had reached their decision, 7-2. The majority opinion, written by Chief Justice Roberts himself, spans 47 pages of meticulous constitutional analysis. Reporters who obtained the complete text described the language as unusually direct, almost urgent. The opinion states that no president, current or former, holds immunity from criminal prosecution for conduct that violates federal law. It explicitly rejects the notion that official acts automatically shield a president from accountability. And in a passage that sent shockwaves through legal circles, Roberts wrote that accepting the defense's position would mean the Constitution creates a king rather than a president, and that the court would not participate in such a distortion of its founding principles. Drop a comment right now if you expected this outcome. I read every single one. Now the situation becomes truly explosive. When the ruling was transmitted to the parties at 3:17 a.m., sources inside Trump's legal team described the atmosphere as total chaos. Lead attorney John Lau was reportedly awakened by a phone call from a junior associate who had been monitoring the court's electronic docket throughout the night. Within minutes, every phone in the war room was ringing at once. Staff members who had left for the evening were ordered to return immediately. The most consequential moment appeared in Section 3 of the ruling, where Chief Justice Roberts addressed the specific criminal charges pending against the former president. He wrote that the evidence presented in government filings, if proven at trial, would amount to a fundamental betrayal of the oath of office that no immunity doctrine could plausibly protect. Reporters covering the Supreme Court said those words represent the most direct judicial condemnation of a former president's alleged conduct since the Watergate era. At that point, it became clear this was not just another legal setback. It marked the collapse of an entire legal strategy that consumed 2 years and tens of millions of dollars in legal fees. When a Republican-appointed Chief Justice uses such definitive language, the defense has no remaining path forward. The decision sent shockwaves throughout Washington. When a Chief Justice appointed by a Republican president authors such a sweeping rejection of immunity claims, it sends a clear message. The arguments were not merely weak. They were constitutionally indefensible. Claims of judicial bias or partisan persecution lose all credibility when the majority includes 3 justices nominated by the defendant himself. How can anyone argue the courts are being weaponized when their own appointees ruled against them? This is not the first time presidential immunity has been examined at the highest level. Recall United States v. Nixon in 1974, when the Supreme Court unanimously rejected Nixon's claim that executive privilege shielded the Watergate tapes from subpoena. That decision ultimately led to Nixon's resignation within weeks. At the time, Republicans recognized that defending the indefensible would irreparably harm their party. The key distinction was that Nixon claimed privilege over evidence, not immunity from prosecution itself. Then there was Clinton v. Jones in 1997, when the court ruled 9-0 that a sitting president could face civil litigation for conduct occurring before taking office. Although that case did not involve criminal prosecution, it firmly established that presidents are not above the judicial process. The pattern is unmistakable. When presidents assert immunity that would place them beyond accountability, the Supreme Court has consistently and firmly rejected those claims. Often unanimously rejected such arguments. Subscribe immediately if you haven't yet. This content is unavailable anywhere else. And let us not forget the first immunity ruling in this very matter from July 2024. The court's 6th Street decision granted partial immunity for official acts, but explicitly left open the possibility of prosecution for unofficial conduct. Many observers believe that ruling provided Trump significant protection. His legal team hailed it as a major victory. Now, however, the situation is different. This ruling clarifies that the July 2024 decision was far narrower than Trump's team interpreted it to be. The justices made devastatingly clear that attempting to overturn an election and retain power unlawfully lies outside any conceivable definition of official presidential duty. The earlier ruling, it turns out, was never the shield they believed it to be. So what allegedly triggered this crushing rejection? According to constitutional scholars who analyzed the ruling overnight, the court determined that Trump's attorneys had fundamentally misrepresented the scope of previous immunity decisions. The opinion specifically calls out what it describes as a deliberate conflation of executive privilege with criminal immunity that this court cannot allow to persist. Here's the kicker. The ruling includes an extraordinary footnote, footnote 23, that directly addresses the delay tactics employed throughout these proceedings. Justice Roberts wrote that the strategic deployment of immunity claims to indefinitely postpone accountability constitutes an abuse of the judicial process itself that borders on contempt for the rule of law. Legal analysts say this language effectively warns future defendants that similar tactics will face severe sanctions. The footnote goes further. It notes that the defendant's legal team filed 17 separate immunity-related motions over 18 months, each time seeking maximum delay. The court took the extraordinary step of documenting this pattern, signaling to lower courts that they should be far less tolerant of such tactics in the future. Don't go anywhere. The most explosive section is coming next. And here's what should alarm everyone watching. This isn't solely about one former president, or one set of criminal charges. Had the Supreme Court accepted these immunity arguments, it would have meant that any president could commit any crime while in office, up to and including violent felonies, and face no legal consequences whatsoever. Once such a precedent was set, there would have been no turning back. Future presidents could have ordered opponents harmed, misappropriated public funds, sold pardons to the highest bidder, and claimed absolute immunity for all actions. The Constitution would become meaningless as a check on executive power. This leaves Trump's defense team in an impossible position. On one side, they face a 7-2 Supreme Court ruling that eliminates their primary legal shield, meaning they must proceed to trial on charges that carry potential decades of imprisonment. On the other side, any appeal of this ruling goes nowhere. The Supreme Court is the ultimate authority on constitutional interpretation. There is no higher entity to appeal to. They must now explain to their client that the nation's highest court has definitively and permanently closed the door on immunity. And here's the devastating part. There is no credible path forward on this issue. Either they go to trial and confront the evidence the government compiled over 2 years of intensive investigation, or they pursue some negotiated resolution that their client has repeatedly and publicly rejected. The legal walls have never been closer. The options have never been fewer. Legal and political analysts are calling this a constitutional earthquake. Lawrence Tribe, Harvard law professor and constitutional scholar, told MSNBC that the ruling represents the most significant reaffirmation of the principle that no person is above the law since the founding of the Republic. He explained that the 7-2 majority, including 3 Trump-appointed justices, makes this ruling virtually bulletproof against claims of political motivation. You cannot claim partisan persecution when your own judges rule against you, Tribe emphasized. Do me a favor and hit that like button because it genuinely helps this video reach more viewers. Even Jonathan Ter. Movement escalated further when Trump himself responded with a series of posts at 5:42 a.m. He called the ruling the most corrupt decision in Supreme Court history and claimed the justices had betrayed both the Constitution and America. He specifically named Barrett, Gorsuch, and Kavanaugh as traitors who had stabbed him in the back despite his having appointed them to the court. He demanded investigations into whether the justices were bribed or blackmailed. Stay with me. What comes next will completely alter how you view the situation. Here's what makes it even more extraordinary. Trump's own response effectively validates the ruling's reasoning. Rather than addressing the constitutional arguments, his reaction was pure fury directed personally at the justices. When your response to a ruling about lawlessness is to attack the judges who issued it, including judges you personally appointed, you have already lost the argument in the court of public opinion. You have confirmed exactly what the ruling concluded about your relationship with the rule of law. Legal experts immediately flagged the flaw in this approach. Neil Katyal, former acting Solicitor General, observed that attacking Supreme Court justices, including your own appointees, for following the Constitution is precisely the type of behavior that convinced 7 justices you should not have immunity in the first place. This response proves their point more effectively than any legal brief ever could. This goes far beyond a single court ruling or a single defendant. It is about whether the American system can hold its most powerful officials accountable when they allegedly abuse their power. If there are no consequences for allegedly attempting to overturn an election and obstruct a peaceful transfer of power, it signals that presidents exist in a separate legal universe from ordinary citizens. It's not just about this case or this former president. It's about whether the presidency itself has meaningful legal constraints. If this blows your mind, hit that like button right now. Here's the situation. The Supreme Court has issued a 7-2 ruling rejecting presidential immunity claims in categorical terms that leave no room for further constitutional challenges. This is no longer merely a legal dispute or political controversy. It is about whether the principle of equal justice under law applies to everyone, including former presidents who believe they should be exempt. When 3 justices appointed by the defendant himself joined the majority in rejecting his constitutional argument, we have entered genuinely unprecedented territory. There is no higher court to appeal to. There is no remaining constitutional shield to invoke. There is only the trial itself and the evidence the government intends to present. If there are no consequences following this ruling, it sets a precedent more dangerous than anything Trump's immunity claims proposed. It would mean that even when the legal system functions perfectly, even when 7 Supreme Court justices agree a president is not above the law, accountability remains somehow impossible. That is not a system of laws. That is a system of men. Keep a close eye on the story. Trial scheduling conferences are expected within days. Trump's attorneys have until Friday to file any procedural motions, and the special counsel has indicated readiness to proceed immediately with witness preparation and final trial logistics. Legal observers across the country are watching closely to see whether this ruling translates into actual accountability, or whether new delay tactics emerge from the rubble of this defeat. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. 7 Supreme Court justices, including 3 appointed by Donald Trump himself, just delivered a ruling that demolishes every immunity argument his legal team has advanced over 2 years. Constitutional scholars are watching to see if the principle that no one is above the law actually holds in practice. Meanwhile, the clock is now ticking toward a trial that the defense has spent 2 years and tens of millions of dollars trying to prevent. This is not just another news cycle that will fade away by next week. This is a constitutional reckoning unfolding in real time. What happens next could determine whether the American justice system can hold a former president accountable for alleged crimes or whether power and delay tactics can indefinitely shield anyone from facing a jury of their peers. The evidence is out there. The ruling has been issued. The constitutional questions have been answered definitively. Now we wait to see if accountability still holds any weight in America. The stakes have never been higher. The legal walls have never been closer. And the constitutional crisis has never been more immediate.